Hi, everybody. I'm Brittany Lewis, a breaking news reporter here at Forbes. Joining me now is Dan Wolff, partner at Crowell Moring. Dan, thank you so much for joining me.
Well, happy to join. Happy to be here. Thanks for the invitation.
I'm really excited to get your legal perspective on President Trump's tariffs today because he promised them on the campaign trail, and since he began his second term, he threatened, started, paused, and ratcheted up trade wars with allies and adversaries alike. He invoked the International Emergency Economic Powers Act of 1977 as reasoning to impose the tariffs, and he has since been slapped with a lawsuit over some of the tariffs he announced pre-Liberation Day when he unveiled his sweeping tariff plan. The lawsuit says that his reasoning behind the levies are unconstitutional. So what stands out to you about this legal fight?
Well, what stands out is the basic proposition of whether IEBA, the statute you referenced, provides the president with the authority to do what he's done in the realm of tariff setting, and the complaint, as it makes clear, is that for at least two reasons he cannot. Either because the statute doesn't provide for the setting of tariffs, or if the statute does provide for the setting of tariffs, it does so in an unconstitutional way because it basically hands over the authority to set tariffs that is vested in the Congress of the United States by our Constitution to the president, and that would be considered a improper delegation.
The nonprofit New Civil Liberties Alliance, who is suing Trump, argues that IEPA doesn't allow the president to impose tariffs on the American people, like you said, and it claims that the president is exceeding his authority. How strong is that legal argument?
I think it's very strong, and it's strong for the reasons stated in the complaint. If you sort of take the first argument, which is one of just statutory interpretation, if you look at IEPA, you don't see any clear reference to the authority of the president to use that statute for purposes of setting tariffs, and that's in contrast to the Trade Act of 1974 or the Trade Expansion Act, which those statutes do provide the president with tariff setting authority. So from a matter of what does IEPA mean, if we just read the text of the statute, it doesn't authorize the setting of tariffs. But then the second point, which is the constitutional point, is that to the extent the statute must be read to allow the president to set tariffs, it does so in an unconstitutional way, and that's because the power to set tariffs is vested as one of the enumerated powers in Article 1 of the Constitution with the Congress. And vested means something. It means only Congress can do this. And Congress cannot thus take one of its vested powers and hand it over to the executive branch. And so I think both of those arguments are strong. I think typical judicial approaches to interpretation would first take up the statutory interpretation question, and the case could stop there, and the court may never reach the constitutional question. And I'm putting aside questions of venue and forum and just looking at this on the liability question.
I want to get your reaction to something that a White House spokesperson told to Newsweek. They said that Trump has broad authority to impose tariffs to address issues of national emergency. As a lawyer, what do you make of that argument? I mean, what constitutes a national emergency?
Well, there's two separate issues. The president may well have authority to determine questions of national emergency, and it's beyond my expertise as an attorney who doesn't sit in the realm of analyzing foreign affairs to say what a national emergency is. But I don't think that's the issue. Whatever authority the president has to determine the existence of a national authority is separate and distinct from the president's authority to set tariffs. And again, go back to the Constitution. Article 1 gives to the Congress, vests with the Congress the authority to set tariffs. It may be, and this is how our political branches act together. It may be that the executive branch is charged with making certain findings or certain determinations that would then inform the Congress to decide what to do about it. But that would be perfectly normal for Congress to take a report from the president and then act on that in its lawmaking capacity. But the fact that the president has authority to determine national emergency is distinct from whether the president also has authority to set tariffs, which the Constitution clearly vests with the Congress.
The lawsuit deals with tariffs that were imposed on Chinese products pre-Liberation Day. So this deals with things before the April 2nd announcement. So does the fate of this lawsuit do anything to the tariffs that were imposed after that? And if it was found that President Trump imposing these tariffs was unconstitutional, does this undo all tariffs?
Well, no. I mean, there's lots of tariffs, and I want to, we're only talking about the IEEPA related tariffs. So, most tariffs are going to be fine. To the first part of your question, though, this targets a specific tariffs that grew out of the February executive orders. As a matter of case precedent, a decision in favor of that plaintiff would certainly provide, a legal authority for others to use in challenging either their own tariffs under the same executive orders or these more recent Independence Day executive orders. Obviously, events of the last 24 hours might affect the immediacy of needing to get relief there, but that's the typical legal process that we have. Court issues a decision. It's subject to appeal, in that case to the 11th Circuit, ultimately to the Supreme Court. Other district courts may come out differently on the same legal question, so it's not binding. A decision in favor of the plaintiff in this lawsuit wouldn't be binding on other the cases brought by other plaintiffs, but it would certainly be precedential, and I think would be something that everyone will be watching the case as sort of a litmus test of what other IEEPA-based tariffs may also be vulnerable.
To your point, since everyone is watching this as this sort of litmus test, do you think we are going to see other legal challenges down the road?
I do. Yeah, I would expect to see more. I mean, this is where there's a lot at stake here, and this is just one plaintiff in one federal district court, and I think there are legitimate questions about whether another lawsuit might be better brought in the Court of International Trade. For example, to challenge on non-delegation grounds, because if IEEPA is construed as a statute that provides for tariff setting authority, then the way to attack that is through the constitutional issue. And I think that, a lawsuit could, be brought in the Court of International Trade. So I don't think this one lawsuit will settle everything for everyone for all time. And obviously the economics and the implications of these tariffs are so great. I just can't imagine that this will be the only lawsuit in this area.
We know that this lawsuit is about the February-related tariffs on China, but since then, President Trump really ratcheted up the trade war with China. Since then, it's been a tit for tat, and most recently, as of Wednesday, he escalated their tariffs to 125%. So let's say that the IEEPA-based tariffs are found unconstitutional. Will this undo the entire trade war between the United States and China?
Well, that probably goes beyond the scope of my particular subject matter expertise. I think that, for the reasons I already said, if the IEEPA-based tariffs are found to be unlawful, either because IEEPA doesn't provide for tariff setting authority or because, to the extent it does, it's unconstitutional, would it undermine the ratcheting up, to the extent the ratcheting up is based on IEPA, it would undermine that tariff or those tariffs that flow from that executive action. Would it unwind the complete trade war? Obviously there are other tariff setting authorities. So, this could go in different directions based on other authorities, that don't rely on IEPA.
So what specifically, when it comes to this legal challenge and IEPA-related tariffs, are you looking out for next?
Well, I would expect, I'm looking to see how the government responds with respect to venue. Will we see a motion to dismiss in whole or in part on the grounds that the plaintiffs filed in the wrong forum? And I'm not saying I'm not opining on whether they did or not, but it would not be it would not be unusual to see a motion to dismiss from the government based on the fact that, as I alluded to earlier, that perhaps the right forum for this is the Court of International Trade. But on the merits, I'm looking for a decision, and they haven't. At least I checked yesterday. They hadn't yet filed for a preliminary injunction. So the only thing on the docket right now is the complaint. And typically the government has 60 days to respond. So barring a separate motion for a TRO or a preliminary injunction, which is the sort of thing we've seen playing out in, dozens and dozens of other challenges to executive order actions, there's really nothing that compels the court to move fast on this issue. And that may be intentional on the part of the plaintiff and counsel, just to tee this up and let it simmer as a political issue, sort of as a sort of Damocles, without any intention of trying to move it quickly. I'm also watching to see if there's going to be other cases, right? Are there going to be other cases either in federal district court or in the Court of International Trade? And are they going to seek a more expedited review sort of on a motion for TRO or preliminary injunction basis? That would speed this up and get the case teed up more quickly than it appears the plaintiffs in the Florida case are so far doing.
Well, there's certainly a lot to keep our eye on, and I appreciate your legal perspective. You are welcome back anytime. Dan Wolff, thank you so much for joining me.
Okay, thanks for having me.